trial knowledge. 11 witnesses have been examined. Now it is at the stage of defense.
11 out of 14 are.
3 have dropped few knowledge.
3 are proceeding.
Yes, sir.
So
now it is
trial
at the
is
stage
on
of beginning.
state of
The defense evidence.
defense evidence.
Next date is 27th November. He has 12 criminal antecedents.
11.
12, 11.
11 or 12?
11, my lords.
11.
It's 11.
11.
My lords, 1 year, 1 month.
No, the trial is almost over.
For defense witness.
So, of course, earlier NDPS cases also involved cough syrup only, or he was dealing with some other thing? There was some. No, but when you give the details of the
my lords,
earlier cases,
my lords, 3 of them.
Just
My lords, 3 cases.
Counter perhaps.
Was IPC. 1 was for the Public Gambling Act, and 2 of them.
3 were NDPS.
Yes.
Or this is the present case. So 2 other ones.
2 NDPS.
2 were NDPS. What were the drugs that you were dealing with there? You should know. What was your client dealing with there in those cases?
My lords, 1 what I know of was ganja.
Ganja.
5
Then
5 kgs ganja, and in Drugs and Cosmetics Act.
No, the other NDPS. There are 2 NDPS. One in 2012, one in 2015.
My lords, 2012 one I know, my lords, ganja. It was.
It was an NDPS. He's regularly involved in these activities. He's selling to the young people, and they are further selling it to the in the society.
This cough syrup, we are in the process of hearing that batch of cases. 16 bottles.
Well, it is 1600 grams. So 1 kilo is the commercial quantity. He's caught up with.
No, that you will have to look at the amount of codeine phosphate, is it not?
Well, it is the judgment.
There seems to be a notification of the Government of India saying that in an undivided preparation.
It says that the neutral substance cannot be excluded. It has to be seen.
But if the government itself comes out with a notification, there's a government notification. Are you aware of that? There's a Government of India notification saying that in undivided preparations, if the codeine phosphate is up to a particular level, it will not come within the scope of NDPS. So we don't know what these 16 bottles. How much was the percentage of codeine phosphate?
It makes it worse. The neutral substance makes the drug worse.
Once there is a Government of India notification, I can't argue against it.
Yes,
if the GOI in its wisdom says that this will not come within the scope of NDPS, so be it.
So I have to see that, but he has prior.
Are you aware of that notification?
Yes, my lord.
What does it say? 2.5%.
Yes, my lord.
2.5%. We don't know what the percentage here is.
My lord,
does it indicate?
Does
your FIR indicate the percentage in the bottle?
No, my lord.
Cough syrup normally contains how much? I don't know.
I have to see. I'll just see and come back.
Most of these are Fensidyl, Fensidyl cough syrup. So immediately, if you can find a medical shop, see how much Fensidyl has.
I'll just find it online.
Pass it over.
Yes, sir.
May please, Your Lordship.
Counter affidavit not filed.
Please, Your Lords. I appear for the respondent number 2. Your Lords,
R2. Who's appearing for R2?
Your Lords, I appear for R2. The R2 is trying to source some documents. Your Lords, we will do the needful within the week, subject to Your Lordship's graciousness, Your Lords.
State also has not filed yet.
No, Lordship. I'll also need.
Learned Council appearing for the State of Uttar Pradesh and the Learned Council appearing for respondent number 2. Seek some more time to file the counter affidavit. Usual order. List on 12th January.
Highly obliged.
Great.
Adjournment is sought by the Learned Council for the respondent to file a counter affidavit. Usual order. List on. This is a.
Bail minutes.
What are the offences? Hurt. Attempt to murder. Sorry. List on 7th January.
Lodges.
Number 9.
So counter affidavit.
For the accused, I filed my Pagalatama day before yesterday only.
State has filed a counter?
Yes, we have filed
You filed
yesterday.
it.
But I may be granted.
Yesterday?
Yesterday we have filed, it may not be
It
on.
may not be in record.
Learn counsel for respond number 2. 6 some more time to you
But
just
first
entered it.
First appearance.
You filed your wakalat?
Yes, not day before yesterday. It's there in the office.
That he entered appearance day before yesterday and 6 some time to file a counter after. Usual order after that. 8 January.
Like-
If the trial is going on, would you lot to consider hearing on that day because the witnesses are now being examined. That's why
Lord, I am being summoned as an additional accused in 319 CRPC. I was not an accused during investigation even. There was a closure report and
No, but the order is the template order that is being followed by the Allahabad High Court.
Lord,
Somebody needs to tell them to at least change the template once in a while.
that we have unfortunate.
Overcrowding of jails.
I may not be, my lord.
Template orders and transfer
that
conditions
your
is all right. We also follow that.
That your lordship.
But in bail matters, at least you should not be
Lord,
following
I bowed
a template order.
I may not be to send behind bars.
Whether it's a
My lord,
302 matter or a 323 matter, overcrowding of jails.
my lord, that's incorrect. Lord, I bow down, but my lord, the lady accused may not be punished for that. That is the I.
Very well, you file your counter.
I will file our reply. Watch out.
Item number 10 have been PC.
May it please, sir. My lord, it's unusually long, my lord. I wouldn't have come and bothered your lordships, but I must tell your lordship,
What
lord,
is this order though? What are
My
you
lord,
agreed by?
my
One
lord,
order reserves
I
judgment.
didn't know how to
The
come, my
other
lord,
order is
either.
an order of adjournment and you have to file a
My lord,
report.
either I
What
come
is
in
it that
Article
you want to
32, my lord, either I come in 32 or my lord, I had to file some SLP. Allow me just
But
one moment to
Your
give your lordship ground reality, my lord.
Reserved, is it?
My lord, it was reserved after 1.5 years. After reserving, it is again listed. When it is
For some
listed in
filing of a report, we can't say that.
no, my lord, allow me just
We
no
have
report actually, my
allow
lord.
some play in the joints even for the High Courts. If the learned judge has a doubt and reopens the matter, we have to go to
My lord, allow me just one moment. Actually, my lord, no report is now taken, and from then onwards, my lord, reserved was on 28th July, relisted on 17th October. After 17th October, it has been listed
31st
now.
October, it was supposed
Now,
to
my
come
lord,
up. What
5
happened
times.
that day? What happened on 31st October?
Nothing happened, my lord. Not even taken
The
up.
report was not filed.
Not, my lord, matter not called out. And after that, 4 dates matter not called out because the my lord court master says this is only for pronouncement and it will be pronounced. So, my
But
lord,
these
matter
are
is
not
not called
orders
out.
that we can interfere with, Mr.
So, my lord, I can only say, my lord, 2 orders I want to show to your lordship, my lord. Punjab High Court itself, your lordship, my lord, said that this practice, my lord, Punjab High Court, your lordship said, my lord, and had given a direction, a bail pending since July 2024. Whether, my lord, allowed or dismissed is, my lord, another thing. But, my lord, your lordships have now passed directions, my lord, that it should be decided. Hussain said 1 week. Satinder Antil said, my lord, 2 weeks. Now, my lord, recently, my lord,
But
Justice
why did you
Partiwala's
go
bench
to
said,
High Court, sir? I didn't understand that. You go to Rajasthan High Court. You also before Punjab.
no, my lord, it's the bail is only before Punjab High Court because
No, but you
SFIO case is in Gurugram. The
You
original
see,
case is in Jaipur.
You obtained interim bail from Rajasthan High Court on 7th August.
My lord, that's an interim bail application because I'm confined in
That's a
several
different
jails.
case. How is it
Different
that you
case,
are going
my
before both
No, my lord,
courts?
no, my lord. The High Court has granted bail in all cases to him because of, my lord, peculiarity of situation. He was, my lord, medically ill. He's a senior citizen.
Well, he didn't undergo the surgery for 1 year. That's the reason why it was cancelled earlier.
No, my
You
lord,
obtained interim bail on the ground that he's going to undergo that surgery, and then he doesn't undergo the surgery for 1 year.
my
Thereafter,
lord,
he's
there are,
called.
my lord, several.
Again, granted
He
interim bail.
indeed has undergone something, my
By
lord.
the Rajasthan High Court.
What today, my lord, that's
What is
Rajasthan High
happening
Court is not under consideration. Under consideration, my lord, what Punjab High Court sitting over a bail order, my lord, for so long. My lord, I am only telling your lordship, my lord, and making a responsible statement. The matter is not being called out. It is not being called out.
We are not inclined to interfere with the impugned orders in the light of the fact that the Punjab and Haryana High Courts, a learned judge of the Punjab and Haryana High Court seems to have reserved judgment in the matter by the earlier order dated 28/7/2025, but the matter seems to have been reopened for the purpose of enabling the filing of a report as the learned judge would be pronouncing orders having reserved judgment in the matter. We are not inclined to interfere at this stage. The special leave petitions accordingly dismissed on that short graph. So you can show it to the learned judge and say that.
My lord, I only say, my lord, your lordships, one word, that, my lord, your lordships expect that it would be disposed of. That is enough, my lord. And my lords have made such observations earlier.
Yes.
Only one line, my lord, that your lordships expect that it will be decided, and therefore, my lord.
I'll add that also.
My lord.
And just say that also. And we would expect that the learned judge would be pronounced.
Deeply obliged, my lords. Deeply obliged, my lords. Deeply obliged.
Non-delay questions also there. So just say delay unknown. 8 days.
Your Lordship, the present FIR has been filed after an inordinate delay of more than 2 years and 7 months. The petitioner has been arrested after 6 years and 9 months from the date of the registration of the FIR. The other co-accused in this matter, namely Mr.
You were absconding since 2018 though.
Your Lordship, but we were present on the production warrant, on the first production warrant. And Your Lordship, we have
the FIR is of 2018. You were arrested only in June 25.
Your Lordship, but the other main accused have been enlarged on bail in this.
That doesn't mean that you just. Where did you go off to?
Your Lordship.
Charge sheet is also filed, but you have not filed a copy of the charge sheet, so we don't know what it says against you. So this selective filing of documents is of course very popular here, but we'll have to take at least draw an adverse inference once you don't file a relevant document. You've not filed a copy of the charge sheet. You say that the charge sheet is filed.
Your Lordship.
You're obviously shown as an accused there because you've been arrested. So we don't know what the charge sheet says against you. You don't want us to see it.
Your Lordship, please give me please one short date.
No. That building up the case as you go along, that is also not permitted.
Your Lordship, but we have been enlarged on bail in other similarly situated.
We find no good ground and reason to interfere with the interim judgment passed by the High Court, especially petitions accordingly dismissed.
Item number 12.
Adjournment is sought by the learned counsel for the respondent to enable him to file a counter affidavit. There's no interim order. No interim order.
Lordship, in item 12, I'd like to appear on behalf of the petitioner.
Date I'll give 19.
No, TCR also was requisitioned in the.
Sorry?
In item 11, TCR also was requisitioned. That may also be there.
In item
11 months.
11?
Sorry, item 12 months.
12?
TCR also was requisitioned, but it is not received so far.
Yes. That was asked for.
Yes, ma'am. With a previous order, it was asked.
Which order was that? You asked for key copies of the trial court reports.
Yes.
So that was long ago.
Long
Not
ago.
been requisitioned till now.
It was requisitioned, my lord.
What does the office report say?
From the office report, para 5. Requisitioned as early as in 2110.
Registry shall follow up and secure the trial court records from the High Court, public trial court, as expeditiously as possible.
Public.
Pleadings may also be completed, Lordship.
Sorry?
Pleadings may also be completed. Counter was directed to be filed, not yet filed.
What
Yes.
pleadings?
No, Lordship, I recorded in the last order that counter was to be filed. They prayed for time,
All
not
that
yet filed.
to do. That is the reason why we are adjourning the matter to enable the
Yes, Lordship.
file a counter.
Great.
Great.
We joined
It's
order.
also incomplete, I was told.
Sorry?
Service is also incomplete.
Service is incomplete.
That's what I was told.
Yes, office.
Office
We are,
report says
we are
minutes.
taking fresh steps, my lord, by the state today.
I see. Service shall be completed on the unserved respondents by the next 3 to 4. Who's unserved?
2 and 3.
2 and 3.
2 and 3. 1 and 3.
Sorry, 1 and 3.
We have for 2.
1 and unserved
Yes.
respond numbers.
Great.
13, adjournment is sought by the learned counsel for the respondent on the ground that the learned counsel on the ground of personal difficulty. However, we find that the counter affidavit has not been filed. File a counter also, please.
Please.
We find that the counter affidavit has not been filed till date. Needful in that regard shall be done within 2 weeks. The joinder thereto, if any, may be filed within 1 week thereafter. Within 2 weeks thereafter. List on 27th and
Please.
Item number 14.
In this matter, replies are waited.
My lords,
R2 is not served off.
I beg to appear on behalf of R2.
R2 is it?
Prosecution
My lords, I'll file my wakalatnama during the course of the day.
No.
However, last order indicates, my lords, that we can make an attempt for settlement. Should the other side be willing, my lords, I'm willing to participate in the mediation before Supreme Court, my lords.
Yes.
Yes.
In fact, the notice itself says,
Yes.
notice order.
We fix a date, my lords, for that.
Very good. Mediation. Okay. This, both parties are here.
Yes.
I appear for respondent number 2, Khushbu Garg.
No, where is she?
My lords, she's in there.
Rishikesh, my lords.
Rishikesh.
Yes.
Sorry, Rishikesh, my lords.
Weekend would be better or a weekday? She works?
First one can be virtually, and then we can decide the
Very
mode of mediation, my lords.
Then 3rd December at 11 a.m.
Very good.
Physical requirement, my lords, they can be the first of it.
Sorry?
Should there be any physical requirement?
Thereafter,
My lords, if my lords can indicate it in the order, my
you need the expenses to
the
be paid.
expenses to be paid.
If she needs to come physically, you will bear the expense.
I don't mind, but she is updated with the maintenance part, my lord, and her aunt is
You want to
residing.
settle or you don't
Yes,
want to
certainly.
settle?
I'm agree with you.
Then you should, that order
Yes.
also.
Grateful, my lords.
Very good. Obliged.
Item number 15.
Wait, please.
Yes.
If your lordships could grant me a short pass over. Actually, I'm led by Mr. Deshmukh. He is on his.
You've received a copy of the counter?
Well, that the counter has been received by them. They had taken some time to file a rejoinder. However,
Not filed though.
No,
Not filed.
You don't need to file a rejoinder?
I have no instructions as to that, my lords.
Well, you did take time on 15th April for a rejoinder,
I'm aware, my lords.
but then we take it that you don't want to file a rejoinder.
No, my lords, I would like to seek some instructions from Mr.
Why didn't you ask for the instructions before you came here then?
No,
If you're aware of the fact that the earlier order records that you were granted time to file a rejoinder, then you must ask your colleague, your senior, whoever is, you're attached to the office of the arguing counsel.
Yes, my lord.
Then why did you ask him then? You should try in front of your senior. Scared or shy?
A little bit of both.
Both, is it? But you're brave before us. It should be the other way around.
Forgive me, my lords. A short pass over would be.
What for? Again, your senior will come and ask for time to file the rejoinder. We find that the rejoinder has not been filed till date. Last opportunity is granted to do so before the next date of hearing, list on 90. This is perhaps a matter for hearing.
Yes.
You want some monetary benefits or something?
the petitioner.
20th January.
Get obliged, my lord.
Please, sir.
I'm appealing for the private respondent, Your Lordship.
Yes.
Your Lordship, his son died due to negligence in the army hospital. Item 69 of Your Lordship.
Some judgment is also there is what
Yes. In item number 16, I'm requesting for a passover. We are led by Mr. Banerjee in this matter. He is in court 8.
you are for the petitioner.
For the respondent, Your Lordship.
You should be here. Unless you've changed your identity, you want to go there. You want to pass over?
And I will be having difficulty in case it is passed over. There will be.
Then we'll give you another date. When do you want?
Your Lordship, any other date will be given, maybe next week, Tuesday or any.
Passover sought by the Land Council for the petitioner, but the Land Council for the respondent states that she would be in the meeting. Matters accordingly adjourned. List on. This will take some time.
It takes some time. We'll take a lot of
You say that it's covered though.
Yes, my lord.
Yes,
Have
my lord.
judgments in our favor.
Your Lordship, judgment are marked, Your Lordship. It will take some time. There are plenty of judgments.
Then we'll give you a Tuesday.
In case there is a negligence.
3rd February.
Then right.
Read it.
Please, Your Lordships.
Yes.
Matters, in fact, this raises an interesting and an important question which your lordships had actually summarized while issuing notice in the matter, my lords. And what arises for your lordships' kind consideration is the issue that
what happened to the order? It's come?
my lord, the plan has been approved.
Resolution
So
plan.
that's the plan has been approved. Now, I'm really not even concerned with it, my lord.
You want to set off during the
Only,
application
my lord, and may I only add, I am not for a minute even suggesting the law is no longer the issue of that even if an arbitration proceeding were to decide an issue, it cannot alter the plan. Your lordships have said two things: the arbitration proceedings can go on, but they will in no way alter the plan, because as far as the IBC is concerned, that will have an overriding effect.
Mr. Kaul, it's better perhaps we take up this matter on another day, Wednesday or...
Very well, my lord, whatever your lordship says.
Sorry, today is the Wednesday. So,
because
but we've got a crowded hall because of the West Bengal matter.
I appreciate that. All that I am requesting is, my lords, if your lordships could consider any Wednesday for the matter that it has some bearing on the larger issues. And secondly, other than that, my relief is very limited. I am neither saying that I will claim anything against the corporate debtor even if I were to succeed. So I am not on the alteration of the plan at all. My limited relief is that it can't happen that you don't give me a value to my claim in the IBC. The corporate debtor proceeds against me in the arbitration, and I, even to the limited extent of a set-off being claimed in an arbitration, can't claim that. And even when your lordships dealt with the judgment of Airtel, where your lordships said an set-off in an IBC. Mine is not a set-off in an IBC. I'm claiming it in the arbitral proceeding. Even in an IBC, your lordships said that ordinarily no set-off, but if it's a contractual set-off, or it is so equitably intertwined in the same contract, the two transactions, that we can look at even under the IBC. In Airtel, it was held to be two separate contracts between Aircel and Airtel. But I'm not even claiming that. It's not that I filed a claim saying that you owe me 20, I owe you 100, so 80 is the figure. I'm just saying that let my set-off be there so that if I succeed and my claim is more than yours, I don't enforce it. But if you succeed against me as the corporate debtor or as the resolution applicant, then if my claim is 50 and yours is 100, I get a set-off of 50 and you can only claim and execute 50 against me. That's the broad issue.
But the broad issue is when there are concurrent findings of court, your lordships, including in the recent BPSL judgment, which we both were on the same side, have said not to interfere. Notice of arbitration, this is already raised in arbitration. It's an indirect way of not touching a...
Well, the same thing was said on the first date of concurrent issues. I said with some, you are pointing out what was already pointed out. And on the first day, my lord, the Chief Justice...
We'll take it up on another...
Yes, very well, ma'am.
Another Wednesday.
Another Wednesday.
Another
Wednesday. When the court is a little less crowded so that you won't have to sweat. Though it's winter, I think already the temperatures are rising. So...
My lords, would your lordships be kind enough to give a specific date?
We'll give you a specific date. Do you want it this side or that side?
January, my lord?
January, yes. 21st January.
Grateful.
This for hearing on
21st? My lords, could it be a week later or a week earlier? Whatever you lord. 28.
28.
Great.
18.
तो मुझे एक हफ्ता बाद दे दो या एक हफ्ता पहले दे दो.
Service is not complete. Because by the time service is completed in one matter, one more fresh matter is added. So there's again an issue of notice.
They are all.
You keep on filing more and more cases. When will the matter ever be heard?
We are doing that the same law, but by that time
you file a fresh case again. Now that
no
item which has been tagged, that's against state of Kerala.
23. I'm 23.
So you have a batch of cases and you're bringing each one into the pipeline now.
Installments.
So by the time the service is completed in the first one, there's a last one which is added where the service will have to be completed. And they're all tagged together, we can't take up the matter for even hearing on interim relief without.
But below one matter, if it is notice complete, we can take it up.
Sorry?
If one matter notice is complete below.
No.
Otherwise,
but they're all tagged together.
That's right.
Once they are tagged, we can't grant an interim order in relation to a matter where notice is yet to be served.
The threat of a contempt
that is not possible. So, stop filing, perhaps complete service, then we can hear it. Don't file any more now.
Let us see. I guess.
Please wait till you finish your arguments on the interim relief. Thereafter, you
I understand.
Sir, as per the office report, dated, just give the date. Service remains incomplete in some of these matters. Steps shall be taken to complete service in relation to the unserved response. This on 4th February. 4th February.
Can it be January middle so that
You have to complete service. There are quite a lot of respondents there.
we are taking all of it. That's justice we are doing it.
21st January.
Obliged.
Lord, we beg to appear in.
19, we'll take up each matter separately.
Yes.
So all of you don't have to start shouting at the same time.
Yes.
That's
And
the only
we
way.
will take
each item, one at a time.
very well, Lord.
So first, 19.
19.
May I please, Lord?
19
Vivek
is
Paria.
appeared. Yes. Vivek Paria.
In this matter,
Now,
the process has
the grievance in this was that the new rules were sought to be applied
Yes.
to the
45
untainted
marks.
candidates.
The original qualification.
And we granted a written order
We were permitted to
So
participate. Now the results have come along yesterday, and the procedure as per the schedule as fixed has been concluded. May I suggest, my lord, this matter may be called up after the procedure.
Why should we keep it though?
No, my lord. The reason is this, my lords.
This is a different one. Arunima Paul was a little different because there I think she was one of the tainted candidates. They come out with fresh food.
नहीं अभी तो announce हुआ result. The interviews will go.
We want to establish two people. That will be 50%. So they wanted to apply the listing so that you're not eligible. But he said nothing to me.
এখানে এসএলপি তে আমরা রেসপন্ডেন্ট কোথাও নেই
Committed.
এসএলপি হচ্ছে
Correct. It has to be a finalized one. Clarification.
And judge there, JD that. Against entertaining the petition. And the ground that the point is that some of the basic angles and the list of basic angles is not being put in a public domain already. We should look into that. So in the first place, the invitation will help the spending laws. So ensure that changing candidates don't come here. If it is taking out such matters, we don't have to keep it. So you let the they can look into it better than we can. I also give
It's on 21st August 2025.
There's one aspect though.
Yes.
The reason why we kept it pending was
because
to see that tainted candidates don't
eliminated.
slip through. Now we find that the High Court has taken up that issue in a writ petition, which is
No, my lord.
pending.
The scope of the proceedings in the High Court is slightly different. We were all
Then-
people who were allowed
then
to.
this issue is also being looked into as to whether tainted candidates have gotten.
That issue is yes. No,
That order is there.
No, my lord. The other issue, may I just clarify? My lord, there is.
You already said all of you will not speak at the same time.
Lordship, the High Court is in season of a matter where those who are not eligible under Lordship's direction.
All issues seem to be there. We will say that the High Court will look into
No, my
all
lord.
issues.
What would happen then
It
is.
would be better that the High Court, being the court of first instance, looks into it. The only
No, but
reason we
Lordship,
kept
my
this
what-
matter pending was at that point of time, the High Court was not seized.
No,
of
my
it.
lord. Insofar as
Now the High Court is seized of a matter where this issue is
my
also
lord,
being
this
raised.
issue, qua
Last item.
Lordship's 20. Lordship should kindly see the. One the going.
Item 20.
Item number 9.25.
Lordship should kindly see the IA that we filed. Lordship should kindly see.
It's better that the High Court decides all this matter.
Service should be counted, Lordship. In item number 19.25, Lordship. Mukesh Grammar.
Lordship, may I just place this one? We have moved an IA in this case. Putting on record a summary of the issues before the High Court. Because the earlier challenge was on multiple fold by tainted candidates also. And the
Item 20.
Candidates which will not be permitted to participate. Here the candidate wishes to publish the list in such a manner that they are. If you look at the order passed by Justice Amrita Sinha, if you look at that order, attention of this court has been drawn to the order passed by the Honorable Court, wherein there is a specific direction that candidates whose names appear in the list of tainted candidates will not be permitted to participate in the recruitment process. Prayer has been made to direct the Commission to publish the tainted list in such a manner so that the identity of the candidates can be properly ascertained. So this issue is being looked into.
So far as the tainted candidates,
Our tainted candidates,
this is our special petition. Kindly see, this is
we will not interdict the High Court from looking into all issues.
No.
Whatever issues
that is correct.
One issue here, because I appeared before the High Court. There is one set of issues which pertains to tainted, untainted, so on and so forth. The second set of issues which your lordships have already taken note of and adjudicated upon is prior weightage, meaning 10 marks prior teaching.
No, that is not even before.
Yes, no.
That's what the High Court
said. You will not apply the new rules to the untainted candidates, so as to keep them out as
your lordships will clarify that.
Court only considering the constitutionality of the new rules.
Yes,
Anyone will also get the weightage mark.
Can I pass on?
The High Court is considering the constitutional validity. That cannot be interdicted at this stage.
Qualified for calling for interview or add it only at the stage of
These
interview.
two questions.
We get filtered out. Cited by the High Court, not even at the inception.
But
now that the High Court is seized of at least how many matters are
Why are they scared of going to High Court? I don't know.
This is our special petition.
You could just
we are not going to stop the High Court.
No. I am not. But there is a finding. Can you see? Hello, excuse me, sir. There is a clear finding that the physically disabled persons who are in the tainted list, they will not be allowed to appear in the examination. But your lordships have said something else in your lordship's judgment.
No. They have never said any tainted candidate will be allowed to be physically disabled, untainted candidate. I remember distinctly Dr. Mukherjee.
Yes.
Yes, Lord. Item number 19.25.
They stand on the same footing as the
Can I trace that paragraph to your lordship?
You should get the benefit of 7 is.
Kindly come to page 68.
Yes, interpreting the order.
Yes.
Paragraph number.
Page 68.
Yes.
Paragraph 47. First I read, then paragraph 48. Some of the appointed candidates who do not fall in the category of tainted candidates may have previously.
What is the other issue? That is with regard to going back to the.
Kindly come to page 48. Paragraph 48. Later we address the case of disabled candidates. Our attention has been drawn to such cases where the judgment held that the appointee Mr. Somadar shall be allowed to continue on humanitarian ground while we will not interfere with the findings. We will make it clear that other differently capable will not be entitled to the same benefit as would contrary to legal principles. However, in consideration of disability, these candidates will be permitted to continue and will receive wages until fresh selection. Next, paragraph 49. These disabled candidates mentioned in the previous paragraph will be allowed to participate in the fair selection process if required with age relaxation and other concessions. But if your lordship
this is similarly indicates that
yes. Tainted cannot appear, but the disabled level is immaterial.
That whatever your lordship, we have no other.
Keep the object.
One request that this issue of
the disabled
Item number 19.25.
10 marks may not be real.
All parties are before the High Court. Then the High Court
again before the High Court to bring in the tainted candidates. We do not understand why.
High Court is not
Because our interpretation we have done it.
all these cases we are going to
At
close.
least this candidate, Bhubaneswar Emma, should get the 7 years.
Let the
very
High Court decide.
Because examination is over there.
All issues you can raise before.
Lordships have already adjudicated.
We are not going to have parallel proceedings.
I have one.
He was appointed with the due process of law.
Prior teaching experience.
Sorry?
The High Court, by
That
looking
High
at
Court will
prior
decide.
teaching experience again.
That is a different issue. It does not come.
But you're not.
Judge.
High Court is considering the constitutional validity, not the same thing.
One of so far as
We are closing all matters.
Seema Das.
yes,
Lordship, kindly
yes,
all these
yes.
You are
affects
the
court.
villain of the piece.
One thing I considered I have
Don't
made.
allow to High Court
Other side.
adjudicate it.
And see, there was a findings division bench regarding the teaching experience which has been given, that has been sanctioned by the division bench. Then one Arunima Pal was the unsuccessful candidate.
She was a tainted candidate.
No, why the School Service Commission is interested in this matter?
Proposing everything against her.
Arunima Paul, I dismissed.
No.
Yes.
Exactly.
Therefore, why the SSC is so much concerned?
Exactly, I'm saying that.
Kindly,
Kindly just hear me for 2 minutes. Arunima Pal, who was unsuccessful in 2016 selection process.
Oh, she was not even selected.
Yes.
Not even selected. Now, in 2025, he challenged that. Against that.
Perhaps you have changed
What
it.
is that? No. Please, kindly allow. No.
No, the High Court is considering the constitutionality of the rules.
This is kindly.
Let the High Court decide the matter.
Kindly just hear me,
You know
Milord.
the decibel levels work at the Supreme Court.
Milord, kindly just hear me, Milord. Just 2 minutes.
Yes.
Without any interruption. Then your lordship will dismiss my contents. I have no difficulty.
2 minutes, start now.
2 minutes, just 2 minutes.
Yes.
Unsuccessful. 2016, 2025, they sat. They became again unsuccessful. They challenged the division bench judgment, where the division bench upheld the provisions of the teaching experience, right? And against that, SLP has been filed. Your lordship dismissed that. Therefore, those who are saying
You
about
need to also see what the locus of that person was.
no.
We did not
Yes.
say anything on the merits of the matter.
Go.
So, mere dismissal of the matter does not mean that all principles in that judgment have been upheld.
Yes.
Because, therefore, all of you go back to the High Court.
Lordships are not deciding the para 47. Para 47 we are on the next category. We are not on the
7.
para 47.
7 you've been allowed to join, is it?
No. I have a
They can argue before the High Court.
Let that not be disposed of by this order in 90s.
47 is people who are wanting
One
to
set
go back
is
to
not
their earlier job.
joined already, but removed and then came back for this, my lord. Your lordship permitted them to go back to their respective departments.
Within the state of West Bengal.
Yes. Now, my lord, he represents about 30-40 people, my lord. What has happened with them is, simultaneously, after they joined in this, my lord, simultaneously they got appointment orders from one other different department of the West Bengal itself. Since they have joined and there was no case pending at that point of time, they could not join the other department, but they continued here.
That's going beyond 40.
Now today I am left with no remedy. We are all age barred.
Kind of candidate.
We're all
Does
age
not
barred.
cover that situation where
we
There
want
are
an offer of another job which you never joined.
there are vacancies.
We only permitted you to go back to the job that you left.
Plus,
Come
we are
into
placed similarly.
There are
Placed similarly.
Similarly, Lordship,
How you
7 years benefit, 7 years job benefit. In item number 9.2.
Just withdraw here and go back to the High Court.
So far as the protection lordship circumvents, that should be made
You
a
won't say anything, whatever you wish to say before
Let
the
us
High
please
Court.
withdraw these
on High Court.
Once,
On High Court.
19.15, 19.16, I'll withdraw.
19 points.
15 and 16.
19.15,
Liberty.
19.1.
All of us will say that, my lord. Same order.
Moana, which one do you want?
19.9 to 19.23. I appeal.
19.9.
9 to 19.
All of them.
All of them. them, my lord, with liberty, my lord,
liberty to
approach the High Court for the same relief.
for seeking redressal.
Also, one more thing, my lord, the findings in the judgment of the court should not come in the way.
Yes. We won't say anything.
Please say that.
19.8 also.
19.1,
All same one.
19.15 and 16.
19.15
and 19.16.
19.38. 19.38.
19.27, my lord.
19.27.
Just one minute. There is one clarification, my lord, would be needed because now after the result, they have published a list only by name. And the list of tainted candidates are there. Now it is very difficult to find out.
High Court is seized of that.
Once
the High Court is seized of that issue, then
One suggestion on the High Court. On the High Court,
we'll make a
clarification in November 23 had
19.27.
Yes, Ms. Makilis.
Courtships have said that 31st December the exercise must finish, your lordships. Now, unfortunately, I've just given this list. There are more than 70 matters which have been filed in the High Court.
That, of course, will have to.
Lordships, let me finish. Where different aspects, there's hair splitting, different aspects are being challenged. I have no problems in the matters remaining pending. All that I'm saying to your lordships is that matters can go on. But let no interim orders be passed.
Yes.
Court hasn't passed any interim order. What is happening?
Allowed to continue with the
Court hasn't passed any interim order. Honorable Supreme Court cannot be.
Tainted candidates have gotten through. They can't get.
Yes.
No tainted candidate.
No.
Other matters which need to be withdrawn.
Objection on the High Court.
Withdrawal matters anymore.
Now we will get this more.
19.25, Lordship. 19.25.
Now we will get this.
If you want to withdraw, say so. No, you're not pursuing it here.
Para 47 of the lordships.
Para 47 orders have already been implemented.
Working in autonomous body in Kendriya Vidyalaya Sansthan, they are not.
Where are you? Why is he not returned to his?
No, we have given everyone. We have given.
In Kendriya Vidyalaya.
Central government is not our government.
Central government perhaps is not a party to it. We have only said the government, which means the state government. State government and autonomous body. Autonomous body, Kendriya Vidyalaya is a central government organization. It's not an autonomous body. It is not an autonomous body.
Plus, going back to the High Court, may I make a suggestion, my lord? Your lordships in November 23, when your lordships order,
you'll have to go back to
there are a lot of matters that your lordships can see. There are a lot of matters, a lot of issues. Your lordships want to send everything back to the High Court. Knows very well. Because in November 23, when my lords had passed a similar order at the interim stage, my lords had said go before division bench and hear it expeditiously. My lords may pass a similar order this time, so the matter can be heard finally. No.
One prayer, my lord.
That's all now. Let us take the order.
Yes.
Your Lordship, please to take up the intervention applications in item
You
19.
should be permitted to continue, my lord, till the time of the case is not.
No further order. High Court will please.
All issues to address
be heard by the High Court.
Yes.
Will Your Lordship be pleased to take up the intervention applications, Your Lordship, in item 19?
Go before the High Court. By this, because we then the state government and bodies which come under the state government.
No, just 1 minute, my lord. High Court. But we will approach the High Court in 2 weeks' time. 2 weeks' time to give us protection.
Will Your Lordship be pleased to take up the intervention applications in item 19, Your Lordship?
WPA 2688 of 2025 has already been entertained by a learned judge of the Calcutta High Court, and various issues were flagged by the learned judge. What is the date of this order?
There are various orders, your lord.
19/11/2025.
Yes.
The matters pending before this court as on date were kept The matters on
My lord, and
matters
7th of
on
November.
file before this court as on date were kept pending. You got the sentence. The matters on the file of this court as on date were kept pending only for the purpose of verifying as to whether or not the directions of this court in the judgment dated 3/4/2025 in state of West Bengal versus Baisakhi were being implemented scrupulously. As we now find that a learned judge of the Calcutta High Court has taken up that issue, we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertakes this exercise instead of this court.
Yes.
It would be open to all the petitioners, public applicants before this court to approach the High Court for redressal of their grievances.
Yes, ma'am.
In accordance with law.
However, the selection process which is underway will not be stopped, Your Lordships.
We will not say anything.
Nothing. What sort of plan is made?
Fix the time.
Direction.
We have fixed the time frame. As and when they come with an extension petition, then you can open.
I should have stopped to any.
I'm deeply obliged.
Your Lordship be kind enough to take up the intervention applications, Your Lordship, implement applications at item 19.
They've already got an order.
Through. None of the tainted candidates are permitted to slip through
11th November, 12th November.
during the fresh selection, be it on one pretext or the other. The High Court shall also ensure that the list of tainted candidates is placed in the public domain.
Yes. Yes.
With full details. With full details.
Grateful. Grateful.
So as to ensure that
And
this does not
the benefit of 7 years.
Your Lordships, it will be Your Lordships to say that it should not be stopped.
when it comes to seek to read more into certain aspects of the judgment dated 3/4/2025 would also be at liberty to raise such hermeneutics, HERMENEUTICS, before the High Court.
Your Lordship said that.
Your Lordships have referred to an earlier the single judge's order. Lords, against that, there are several other orders. There is an order of 12th of November.
19th November.
7th November.
11th November.
You want those also? Same learned judge. 11th November. 12th November. 19th November.
11th November.
20th November.
In those orders also issues have been flagged.
All issues. And
Both
them are
7th, 12th and 19th.
7th,
11th,
12th.
7th, 11th, 12th and 19th.
And the judge is hearing all the issues. Let it go.
Of successful candidates also, so that it can be compared, right?
7, 11, 12.
Compare this.
Compare what?
7, 11.
Those who have succeeded in the exam.
19.
Why would we want the untainted candidates to be open? That's unnecessary.
Able to know.
Unless the High Court is now on a time frame, they have to complete it as
The matter is fixed on 28.
Lordship be kind enough to take up the intervention applications, Your Lordship.
cases and the applications
Yes.
are disposed of in the
Deeply obliged. Deeply obliged.
Consider saying uninfluenced in our
Like this will ultimately bring the industry to quadrant.
High Court can look into it. Matters uninfluenced by
Yes.
any of the observations on merits made by this court in the earlier orders.
And one more line, not to kindly add one more line. Untainted candidates.
Now get out of.
We've already dismissed as withdrawn various matters. You want to withdraw?
Lordship, these are the cancer patients. We have claimed the similar relief orders on humanitarian grounds.
That was refused by the court.
Dealt with cancer patients and all that. We only said dealt with physically disabled candidates. Soma Das was a blind. Cancer and blind. She was a physically
The
disabled.
court categorically held Soma Das case will not be applicable.
She was a physically disabled candidate too. She might have had cancer also, but she was within our scope only as a physically disabled candidate.
Because the matter is listed day after. This order may be uploaded today. It's listed day after.
Uploaded today.
The High Court. Very great.
So far as
Go before the High Court.
My lord, only one
Extremely obliged to the Honorable Court.
If your lordship may be kind enough, your lordship, in item 19.
Go before the High Court.
Now vacate
Already given
space,
that.
space for others.
My lords, your court will now empty out, my lords.
Yes.
Lordship, insofar as
Lordship, in item 19, the intervention applications.
Actually, the first item we were permitted to participate on account of the old qualification 45. Lordships may clarify that
You've already challenged those rules.
No. We repelled by the High Court. It was we succeeded in an appeal, and then we are here, my lords.
The High Court shall also be mindful of the fact that the
21st August
candidates during the past election were allowed to sit for the exams.
In terms of this court,
for the selections afresh, to be held afresh, and their candidature cannot be adversely affected by application of the new rules. Which
Grateful.
And one more line, Lordship. I want
to these tainted, untainted candidates.
Untainted candidates. They have examinations.
untainted candidates should get the benefit of 7 years.
You want to weed them out?
No. Why?
If I say for Lords may retain this matter.
You come up with these new rules and you try
They were permanent in their job.
because of our order, there is
Yes.
Item 19 may be retained, my lord. Because of
And 20 also, my lord.
Not this anywhere.
Item number 19.25.
We have
Please,
given
Ahmed.
10 marks for experience.
you will be giving them all 10.
All
the teachers, untainted teachers, will be.
We are all untainted.
At what stage?
Will you be giving 10 marks to all?
10 marks if he has
Weighted.
for first year, 2 marks. If they completed 5 years, 10 marks.
Well, 2019 was all of them have 5 years.
Yes, now we want
Yes,
that is the reason why we asked them, you are benefited by this.
No. Decibel is that side higher. Now
you have the microphone.
What has happened in the written examination? Some of the untainted teachers have secured only 26 and 30 marks.
And 7.
So they get these 10 marks though.
Even they have added 10 marks. Given educational qualification 10 marks. Even in that case, they are less than fresh candidates. Yes, marks are less than fresh candidates. Therefore, also say that all untainted teachers have to be allowed. Then it is.
We have not said they will be allowed. We said that you will
disqualified.
Adversely affected.
Their previous experience should be counted.
This 50%, 45% you cannot apply.
Yes.
Too much. This is too wide because freshers are also coming within this position.
What are आपको समझ में नहीं आया मेरे को.
But this new rules will be applied also to the freshers? No.
New rules will not be. See,
to me, freshers and
when we asked you to undertake the selection of fresh, we did not contemplate that we will add new vacancies and bring in fresh.
Yes.
The intention was that you would hold a fresh selection for these untainted.
Yes, but Lordship, untainted candidate, Lordship, their previous benefit should be added, Lordship.
On top of that, you bring in new rules. Then, once you bring in new rules,
That High Court appeal is pending.
People whose selection has been set aside and they've been given another go. That doesn't mean that you apply the rules to them.
Your lordships have said to appear in.
Nonetheless, let these matters be now argued before the High Court. Why he is wasting?
Selection would start.
Giving of 10 marks to untainted candidate, that is
an examination, a selected candidate, the untainted candidate
should be asked for permission to frame new rules and apply it to the untainted
to create all trouble.
Did you ask for that?
We have.
You've done that. So far as these untainted candidates are concerned, their candidature shall not be adversely affected by application of these new.
My lord, then in that case,
Greatly obliged. Greatly obliged. Greatly obliged.
candidates who have secured lesser marks than the first.
That selection, whatever you
That
wish to do,
is go by the rules. Go by the rules. It doesn't go by the interpretation.
Clarify that.
That is all. That is all.
That's all. That's all.
For test after 10 years.
That's all.
Yes.
That's
Lordship, in item 19, Your Lordship.
High Court is considering a matter. Let the High Court do it.
Nothing. We've said that the unlisted candidates.
Lordship, kindly add one line, Lordship, in order. Their previous.
My Lord, we will not.
19, Lordship.
End it now.
Your Lordship, I have an intervention application, Your Lordship, in item 19.
No doubt about it, and then also obviously come back to me.
We all want to be heard by your lordship, my lords, always.
No.
We always want to be heard.
We've not said anything about that. Why should she say anything? You sensitize the High Court that they are great.
I am ready, Lord, whatever your lordship says. I think your lordship said that all tainted candidates will be taken into the employment.
Tainted candidates.
Untainted.
You said tainted.
Whatever is there in the order, no further clarification necessary.
There should be a separate hearing, Lordship. Untainted and tainted.
No.
You didn't say untainted.
Untainted. If your lordship desires.
Then SSC is much interested to see that the corruption again.
In a competition, they are lesser marks.
In fact, not they should have held a separate selection for us. They didn't do it.
Next.
Because we are grateful, my lords.
Yes.
Could the appearance be given physically?
Yes.
Grateful.
19.37 also. 0.38. 38. Oh, he doesn't want to. This is 37. 27.
24 is of the same one.
24, you want to withdraw?
No, this is the same one.
Same one. 24, same one.
20 council has come in or still battling at the door?
What is empty now?
Yes.
And no more sweat, Your Lord.
But then what Mr. Gopal Subramaniam is equal to all of us.
Now you'll be elegantly addressed by Mr. Subramaniam, my lords.
That's why it said one is equal to all.
And the football rabble-rousers are going to leave, my lords.
Sorry?
Football rabble-rousers. My lords, we gave you the atmosphere of Mohan Bagan versus Mohammad Al-Spotted. It was like you were in West Bengal. Grateful, my lords.
Yes, 20. Yes.
Please, your lordships. Look, the issue is a short one as far as the.
It wouldn't be short with you appearing, Mr. Subramanian.
Not, I try to be as concise as possible.
There are cross appeals, my lord.
Yes.
One issue, my lord, they have succeeded. On the other issue, my lord, we have succeeded, my lord.
Yeah.
Lord, there are two appeals.
Yes.
That is Civil Appeal 9701 of 2025. Lord, I beg to appear for the appellant in that appeal.
Yes.
The companion appeal is Civil Appeal 12367 of 2025, which is, my lord, the appeal which my learned friend Mr. Mehta referred to, where, my lord, my learned colleague Mr. Sibbal appears on behalf of the very same party.
Respondent.
Yes.
For the respondent. Yes.
My lord, this present appeal, my lord, is directed against the judgment of the National Company Law Appellate Tribunal of the 24th of January 2024. And in substance, my lord, it affirms the order passed by the National Company Law Tribunal, which rejected, my lord, the petition under Section 7 of the Insolvency Code.
Lord, one small interjection, if you lordship, if not mind. Lord, I respectfully submit, my lord, the question which is answered against us, my lord. Just give me a second. If, my lord, we address your lordship on that point, my lord,
the issue, my lord, which is decided against them will become irrelevant. So in case your lordships would like to hear that point first, I leave it to your lordships.
Or may I just set out my facts, then I'll be in your lordship's hands. Let me lay out the facts, and then after that, Lord, your lordships may take over. My lord, let me straight away bring to your lordship's attention what happened in this case. My lord, there are two entities who are involved in this matter. One of them, my lord, is called ESL, and the other, my lord, is ECL. I'm just, my lord, using an acronym for the purpose of convenience.
Yes.
My lord, ESL, if your lordships will see, it has a slightly longer name.
Electro Steels.
That's right, my lord. Your lordships will notice that it is Electro Steels Limited, ESL, which is the principal borrower.
Yes.
Electro Steel Castings Limited is, my lord, the party whom I am pursuing.
Yes.
And according to me, my lord, it is a guarantor. And there exists, my lord, a contract of guarantee, which can be subjected to the regime in the IBC. So, my lord, everything really revolves around the question whether there is such a relationship as a guarantor, whether a contract of guarantee is discernible, and if it is so, then, my lord, logically, the applications are maintainable. The NCLT, my lord, came to the conclusion, after examining the various documents in question, that a contract of guarantee was not made out, and therefore the application was incompetent. My lord, in the appeal before the National Company Law Appellate Tribunal, the Appellate Tribunal, my lord, concurs with that for slightly different reasons, but, my lord, reverses a finding and says that in fact there is no extinguishment of liability on account of the resolution plan, because, my lord, various reservations are contained in a resolution plan, that this does not in any way impact or impinge upon the liability of a guarantor, liability towards a guarantor. Well, this is just the broad view which I wanted to place for your lordship's consideration.
Yes.
Now, my lord, let me place some documents, because ultimately, my lord, under section 126 of the Contract Act, we have to examine, my lord, what is the law and how has it been defined. My lord, I must say, there is a distinction which is often drawn between guarantees which are called on-demand guarantees, like, my lord, bank guarantees, which on site you are meant to pay the money which is guaranteed. And you also have, my lord, what are called guarantees which really are intended to ensure the performance of an obligation. These, my lord, are colloquially called in English judgments as to see guarantees. That is, you ensure the performance of an obligation on whose behalf you are an obligor. So, my lord, the expression obligor or the word guarantor, my lord, these are all words. But ultimately, your lordships would have to see that is there an element of undertaking? Is there an element of voluntariness? That in the event that there is a default, then this person will do what is required to remedy the situation, that that person will not be in default. So, my lord, if the extent, if I may say so, of assistance or obligation which is undertaken by the obligor is coextensive with what was the obligation under the contract of the principal borrower, then, my lord, it amounts to a guarantee. Now, my lord, this is the real question which arises. My lord, there is a recent pronouncement of this court. There was a question, my lord, again under the IBC. There, my lord, it was styled as a deed of hypothecation. And the court examined the question. It may be christened as a deed of hypothecation, but if it has the constituent elements of section 126, we will not hesitate to treat it as a contract of guarantee. So, my lord, it appears from, I'm just stating the principle, I will make it good with reference to many of these judgments, but, my lord, it is suffice it to say
the nomenclature, my lord, does not really decide the issue. It is the constitutive elements of a guarantee which must be discernible. And if they are discernible, then, my lord, notwithstanding, shall we say, pleading, notwithstanding for the matter of fact, my lord, something said which is inconsistent with it may not necessarily decide the issue. It is, my lord, preponderant evidence of the presence of these elements which will lead to the existence of a contract of guarantee. Now, my lord, that's the burden which I have to take for the purpose of succeeding in this appeal.
Yes.
So, my lord, may I take your lordships to the various documents, because I will take them in a chronological manner, and your lordships will then come to a view whether they militate against the existence of a guarantee. Well, the first document is Annexure A2, which is the sanction letter, which your lordships will find is in volume 1, your lordships printed page 204.
Yes.
So, my lord, I'm using a soft copy, but I have also noted down in the notebook, my lord.
We are old timers. We use hard copies.
That might be.
So just add, Milord. My friend said he laid down the facts.
Oh, Mr. Mehta has vanished.
No, he'll be here. He'll be here. Milord, it is better to first note who was the debtor.
Yes.
What was the resolution plan? What did it say about the debt? Does the debt survive after the resolution plan? Because you will go to a guarantee only, Milord, if the debt survives. So if it is one of our points, then once the debt is fully discharged, extinguished, there's no question whether you have or you don't have. So it may be better if you first start, Milord, with the fact as to who is the debtor. My friend is an assignee of a creditor who was a part of the plan. It's better to probably look at those factors.
May I say,
or I can.
May I say, my lord, each one has his own rhythm.
It's okay, but
my learned friend may take it. I will
We
certainly.
are aware of those facts, Mr. Gordon.
No, otherwise,
We are aware that we should look at the
you are going straight to a guarantee without seeing what the debt is.
We are aware of the fact that he's an assignee of
So, yes.
SREI.
Nothing is going to be missed. I assure my friend that nothing will be missed.
SREI is a short form, or the name itself is SREI?
No, my lord, it has got a slight name. SREI Infrastructure Finance Limited.
But SREI is a name by
Yes,
itself.
yes,
SREI.
that's the name.
I thought it was a short form for something else.
So, my lord,
also
first,
IBC.
They are also in IBC.
Yeah.
my instructing attorney says that they have fortunately come out of the island.
Come out of it. Yes.
If they were in IBC.
Now, my lord, let me take the first document. That is page 204. This is, my lord, the foundational document, which is the sanction letter. And this, my lord, your lordships will notice, is addressed to the principal borrower, Electro Steels Limited.
Yes.
We write with reference to your aforementioned proposal and subsequent discussions on the subject. We are glad to convey our final approval for a rupee term loan for the above, as per the terms and conditions set out in Annexure 1, which are indicative and not exhaustive. The above facility is also subject to the terms and conditions to be enshrined in the loan agreement and other transaction documents, agreements, financing documents to be executed at a later date. Well, the reason why I'm reading this para is that as an assignee, well, ultimately I was an assignee. The assignee, in fact, assignment took place after the sanction of the resolution plan.
Yes.
And according to me, I'm a valid assignee and I have to derive my rights in terms of the underlying documents. Now, my lord, after this, if your lordships would be good enough to see further, my lord, at the bottom of this, there's a reference at printed page 207 to two annexures, Annexure 1 and Annexure 207.
Yes.
Then, my lord, we now look at the annexure, which is the term sheet. Your lordships will find the term sheet printed page 208, facility amount, rupee loan commitment, rupees 500 crores only. Your lordships will find that.
Yes.
That is, my lord, the facility which has been given by this sanction letter.
Right.
Thereafter, if your lordships will now come to the next, please come to printed page, my lord, 222.
22. Yes.
Your lordships will notice on the left-hand column, promoters, sponsors, partners, undertaking. Now, my lord, I submit with respect that as far as ECL is concerned, my lord, the person whom I am pursuing as a guarantor actually is a promoter within the definition, my lord. And this promoter, sponsors, partner shall furnish an undertaking that the promoter, sponsor shall not without the prior written approval of SREI transfer, assign, dispose of, or pledge, charge or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed prior to the date of first disbursement. To arrange for additional funds, now, my lord, please mark item 2. To arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun, if any. Number 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. Now, my lord, according to us, this is a substantial obligation, and your lordships will find this gets strengthened and strengthened as we go along. Now, my lord, the next document which I want to place for your lordship's kind consideration is the document which is dated. Well, this is the sanction letter. There is another document which your lordships will find is at printed page.
Do you ask for any acknowledgement of these terms? Or
no, my lord, this is what they wrote. This is the first. After this, your lordship.
This is Sray's letter to Electrosteel.
That's right. Now,
so do you,
this is
do you
what
also ask for some
it has been
acknowledgement from them?
Yes, yes. Not only that. Now, please kindly see, there are further agreements. Yes. Let me now show, my lord. Please come to printed page 248.
Yes.
This document, my lord, begins at 247.
Yes.
Please see. This is in pursuance of our sanction letter dated 26th of July 2011, bearing reference number so-and-so, sanction letter wherein we had conveyed our approval for extending to you
Do you also have a list of dates or
I have. I'll hand them over. Yes, certainly. Just get out, Mr. The one. Get the Mr. We'll just, my lord. Please see, my lord, at page 2, printed page 247.
Yes.
This is a second letter of the same date.
Yes.
And please see, we would like to inform you that after conducting due diligence of the project and further discussions with you, in addition to the terms and conditions set out in the sanction letter, we shall require you to provide such additional security as stipulated hereunder. And your lordships will notice at the bottom of that page, we would like to further confirm that as on date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal or corporate guarantee from Electrosteel Castings Limited is required for securing the facility. Now, my lord, this sentence, this one sentence is being, my lord, actually used, repeatedly relied upon to say that there is no corporate guarantee because of this sentence. But, my lord, really, if one reads the tense of that sentence, it says this as on date, that is, as on that date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal is required.
Who is he?
My lord, he happens to be the promoter and managing director of the group, my lord. This gentleman, Mr. Kejriwal. Or corporate guarantee from Electrosteel Castings is required for securing the facility. So, my lord, it was not a condition precedent on that date. Now, we will see how things develop thereafter to determine whether there is a guarantee. As on that date, it was not required. That's fair. But my lord, this does not in any way, if I may say so, impinge upon documents which are executed later, actions and transactions which actually suggest that, my lord, ECL undertook its obligations like a guarantor. Now, my lord, this is the document. Now, please see, your lordships will now come to the loan agreement itself, which is at printed page, my lord, 250.
Second one.
And in this, if your lordship will notice, this is the loan agreement. In the loan agreement, my lord, the parties are.
Yeah.
It's still, I suppose, my lord, the first volume.
Sorry?
It's
the second one.
I think.
Rupee loan agreement.
Yes.
Yeah.
This, my lord, is the agreement.
Yeah.
This is dated, as your lordships will see, this is also dated 26th of July, 2011. And please see, my lord, the parties are SREI and Electro Steels. Then please now come, my lord, straight away, as your lordships will see, after all the terms are properly defined, your lordships may kindly come to page, I'll just give my lord the printed page. This would be, yes, 386, my lord. Yes, I have that. 386.
Yes.
My lord, on this day, your lordships may also notice that ECL was having the largest percentage of shares in the principal debtor. And please now, principal borrower, promoters' undertakings. Does your lordship get that?
Yes.
At printed page 386. The promoter shall furnish an undertaking. Now, my lord, we have moved forward. Shall furnish an undertaking. The
What is the date of this agreement?
Well, look, this is also 26/11/2011.
Same day.
Yes,
Same day.
same day. 26th of July 2011.
So everything happens on the same day.
Yes, my lord.
Yes.
The promoter shall furnish an undertaking that the promoter's sponsor shall not, without the prior written approval of SREI, transfer, assign, dispose of, or pledge, or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed in the disclosure letter. Now, my lord, this first condition, which imposes a restriction upon your ability to deal with the shares in the borrower entity, is indeed a restriction. But this restriction, my lord, is only to indicate that there is a constituent obligation which is placed upon the guarantor, well, not subject to his being called a guarantor, to arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun and a gap in means of financing, if any. 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. This, my lord, is the obligation. After this, if your lordships will kindly go over to, my lord, please see printed page. Let me show, my lord, that is clause 6.3.1. That would be, my lord, at printed page 335.
330.
Yes, I just needed to show that, my lord. That's where the obligation lies.
Who signs this document?
I'll just indicate, my lord. My lord, only the borrower and Shrey.
Where do we find that?
My lord, we'll find that, if your lordships will find. At page 466, my lord. Printed page 466. It's just 416, my lord. 416.
416.
Yes, at the bottom, your lordships.
There are no signatures there. It doesn't. 416 has both ESL as well as.
Yes, my lord. Yes.
Is that part of this agreement or is that a separate document?
That's a separate document, but I'll give you the signature page, my lord. 378, my lord.
37. Signed and accepted.
Common seal of Electro Steels Limited, pursuant to the board of directors. Yes.
Sorry, page 3.
In the presence of so and so, authorized signatory of the borrower who has signed this.
We'll continue after lunch.
Certainly.
But we'll be a little late perhaps because we have a full court meeting today. We can't tell you how long we'll be. You can have a cup of coffee, extra cup of coffee before you come back.
My lord, may I please mention item number 3, my lord. We want to withdraw it, my lord. Item number 3.
Number 3. 3 is passed over?
No, my lord. The argument was heard, my lord.
And then
has asked
dismissed.
Yes, ma'am.
We want to withdraw it after the event.
Item 3.
3.
Dismiss.
He doesn't want the trial to be expedited.